orders entered no longer apply. So the parenting plan goes away. And then this again talks about the child support or spousal maintenance entered in the decree of legal separation no longer applies, except the sums owed to the state. So if the state's involved in the case, those fees will still be owed. And one of the things I wondered about this process is when we do agreements, the parties agree to like waive child support and arrears or spousal maintenance, any of that. We do know that they're still responsible for the clearinghouse fees. I'm assuming that's going to be the same here, but I don't know yet. Haven't experienced it or spoken to anyone about it. So it's a possibility that the clearinghouse fees may still be owed as well. All right. This I think is really important. And one of the things I think that baffled the judges is what happens with the creditors. Both parties have to acknowledge in the termination that it does not impact the right of the creditors, and that if they have relied on the terms of the decree of legal separation, that stays in place. And then there's also the rule that goes with the statute. And very similar to what was in the statute, if it hasn't been converted to a decree, then you may stipulate to terminate it. You have to file under the same case number. The stipulation must meet the requirements of Rule 69, and each party must personally sign the stipulation. And then the terms of it, both parties agree, and they're restoring their marriage. The marital community will be reformed, and then addressing the property and debt. So it's just really the rule that goes with the statute. And same thing with any property payments due from one party to the other, unless waived unless specified in the termination order. And that the parties acknowledge that any parenting orders entered no longer apply. The child support and spousal maintenance entered no longer apply, except for what's owed to the state. And each party waives any claim for amounts that remain due while the support provisions under the legal separation decree were in effect. So arrears. And that they acknowledge the termination order, that it does not impact the rights of the creditors. And then an order, this is where the rule, the statute saying stipulated order, the rule seems to be saying a stipulation in an order. So a proposed order must accompany the stipulation for the judge to sign off on. Any questions? Okay. The next section is, I feel like I'm the promoter of this rule. This is something that I don't know if it's like people are not aware of it, or if people are afraid to use it. But Rule 14 changed in 2019, and what it did is there was Part A and Part B. So Part A, I think, is the same. There's a new change that has come into this, and I'll explain that in a minute. But in 2019, Section A of this broke down the 4 types of documents that have to be notarized. Outside that, what is now Section C was B. It talks about unsworn declarations under penalty of perjury. So all the documents that are not in this section, which is an acceptance of service, application affidavit of default, a consent decree, or a stipulation or agreement that changes the terms of legal decision making or parenting time. Those documents from 2019 forward, when this rule came into effect, no longer needed to have the documents notarized. And so that's petitions, responses, and that's a big part of it. Petitions for modifications, petitions for dissolutions, petitions for legal separation, responses to all those. they no longer needed to be notarized. And this was a rule that people seemed to be scared to use as well. I even had family court call me one time and ask me why I'd done something a certain way, and I had to refer them to the rule. I was kind of surprised by that. But let's say you're doing a petition or a response, instead of having the signature line with a notary block, if you have this statement under this rule, I declare under penalty of perjury the foregoing is true and correct, then you can have them sign or docu-sign it. And I've been doing that since 2019. But now what the change is during the period of COVID, there was an administrative order that came in from our Supreme Court, and it came in like April 2020. And it basically, it's due to COVID, it was allowing those documents under 14A not to be required to be notarized. And you could docu-sign or sign and then provide a copy of your driver's license or government ID. And that was sufficient to cover the notary requirement under 14A. Well, that particular administrative order was extended all the way out until the end of last year. And then when it expired, this rule came into place, B, which may B become C, but this is the alternative verification, and it was written and put in here, and the Supreme Court, voted on it to continue this administrative order that allowed you to sign and docu-sign and provide a copy of the driver's license or whatever government ID, but it's rarely used. And I think it may be, again, like it was in 2019, it may not be known, or people might not be aware of it, or people are afraid to use it. And I can understand that. But this is, we are allowed to do this. But one thing I do want to point out that I think is really important is under this alternative verification, for the documents that require verification under Rule 14A. So let's talk about consent decrees. Courts may accept for filing any documents without notarization if they are accompanied by a photocopy of the filer's driver's license or other government-issued identification document. So it is still within the judge's discretion that they do not have to go by this, and I guess that can cause concern. But what I've experienced so far this year is most judges aren't. I know one judge that isn't, and I know one commissioner that isn't. But in relation to the summary consent decree process, because you've got that 60-day waiting period, what I do in our cases is everybody docu-signs everything and then provides a copy of their driver's license, typically the driver's license, and we get it filed and submitted to the court. So the process has really been speeded up by that. But you do have the potential of a judge saying, it says may, I don't have to do it. I'm totally against this. I'm not doing it. So during the 60-day waiting period, I've just been checking in with judicial assistants to see if it's going to be, an issue. And if there is any issue, then we can have the parties in that 60-day waiting period go ahead and notarize their signatures on the consent decree and get it submitted before the 60 days expires without delaying the case. And I just had one where the judge is like adamant about not accepting it. And I'm afraid to say, do you know the rule? And then I had a commissioner that is having an issue with it, and she issued a minute entry. So I can understand, people being reluctant to do it. I would love to see it done more so it becomes more the norm, and judicial assistants are seeing it all the time. And then this could be something that everybody could use that could make, you could have acceptances of services, DocuSign, and a copy of the driver's license. You can do it for applications and affidavits, the default. We're reluctant to do it on defaults because we're not sure if all the commissioners will accept it. But if this could be more used and become more commonplace, then I think it could be, helpful to everybody that is involved in family law, because it basically takes it down to almost hardly anything needing to be notarized. Another thing to point out about this, though, is it does require the driver's license or government issued identification document to be redacted. And under Rule 43.1, So I added that in here as well. For the most part, it basically says when you go to this rule for a driver's license, it's the driver's license number you want to take out. And then if there's another type of identification, these are the main things that are considered sensitive data under the rule. This particular rule, I know that it was put into place. So if for whatever reason, one of the parties do not want their driver's license or government ID to become part of the record, this is a way to file where it could be filed separately, and then it's protected where other people can't see it on public record. And then, let's see, what was this? This is more information on just the redaction. So we do, of course, redact most of the time their driver's license. We do redact the driver's license number in accordance with the rule because it is stated here that it needs to be done. So I'm curious, is anybody else doing this, utilizing this rule? Did they utilize the administrative order during the years that we had COVID? Nobody? Well, it's something that, I mean, I urge people to look into it and consider using it. I know that people are going to be skeptical of it and they don't want to risk having any issues, but the stipulated order I did for the legal separation, I had that DocuSign that provided IDs and it was signed off in like a few days and they had their court order and they were happy. But I can see where those might be a little more risky. Sometimes when I'm doing something like that, I just call the judge's office and say, does your judge accept this under the rule? And they say yes. And then I've already have confirmation and can tell the parties that. But under the summary consent decree process, you don't know who your judge is going to be when you file the documents. And there's two ways that could be handled that I can think of. One is you just, like I had mentioned before, if you're submitting all the final documents when you're filing the initial documents, you just need to check in with the judicial assistant to see if there's any problems, and then you can get that taken care of during the 60-day waiting period. I also let the parties know from the beginning, we're going to you can DocuSign, but if this is a new rule, there might be judges that don't accept it, and if that happens, then we'll just have you do your notarized signatures then, and they seem fine with it. The other option could be that if you are really paying attention to the judges that accept it, that for sure is not an issue, then you could file the summary consent decree, hold off on the final documents, and then make a determination from there whether the documents can be DocuSigned with the ID under this rule, or if they need to be notarized to be safe. Any questions? Any comments on this? I really would like to get some feedback on it.
Jessica Worley has a question or a comment. Go ahead, Jessica.
Okay.
Hi, Kelly. I was wondering, for the summary divorce process, does it go before the judge or a commissioner?
It goes before the judge. But we do have a couple of floating commissioners.
Right. Okay. I would just never use the DocuSign process for like what you said for default because of how the commissioners.
I have not. I've been concerned about that too. I'm hoping some point in the future we can be more comfortable with it. But even when I know a lot of us kind of schedule with the same commissioner where they let us do that. But if something happens and another commissioner, like they get sick or they can't attend, be there for the hearing, then you could get a commissioner in that is like, totally disagrees with it and will not allow it. And the rule does say may, so a commissioner can make that decision as well. So yes, on default process, we have everything notarized to be safe. But I think that's sad because there's a rule that allows it. But during the time when the administrative order was in place, we did not do the DocuSigning with defaults as well. We do them with consent decrees and documents that are going to judges.
Okay, thank you.
Sure.
Anybody else? Any questions or comments about what we've gone over so far? No, it's great information. It's at least good to know. I can definitely foresee there may be specific clients that for various reasons this would be very beneficial to take advantage of.
Absolutely.
So.
Especially, I mean, I think all of us sometimes have people that are in other countries. So, or they're moving and they're not going to, you know, be around, or they're going to be in a remote area. That's another thing that it's really helpful for, is when someone's in a remote area. Okay. So the next part is on spousal maintenance. This is all in process right now, but I did want to make everyone aware. There is a change to the statute, but the big thing happening is they are in the process right now of putting together spousal maintenance guidelines. It seemed to me, listening to some of the attorneys about it, they seem terrified about this, but I don't know how they're feeling going forward from this, and I'm sure a lot of them are giving input. This information right here actually came directly from Judge Cohen. It was some information he put out for Maricopa County Bar Association. But he talks about these are amendments. There are amendments to the 25-319 for subsection A. None of there's no major changes. Rather, the factors for awarding spousal have just been reorganized. But the big one under subsection B is our legislation last year decided that they wanted to change spousal maintenance, and they wanted guidelines put into place. So, and one of the senators that were sponsoring this bill, he was of the opinion that spousal maintenance should not go past 4 years. Well, that didn't make it through, and a lot of people were kind of baffled by that one. But you can tell the attitude towards spousal maintenance is really changing. I personally think it should, because my understanding is when it was created when our culture was very different. Women were staying more at home with their children, and men were the money makers. I mean, this stuff was created a long time ago, and everything has changed since then. So I'm kind of excited about it. I think it's time. It's overdue in my thoughts. But basically, the major thing right now that is in the statute, and Judge Cohen emphasizes this, is they're changing. The main thing that's changing is that it should only be awarded for the term and amount necessary to achieve financial independence. So that is the major change, along with the guidelines coming in. And he says that while this policy has been generally recognized as far back as the 1980s, and they puts a case in there, there have never been limitation language as we now see it in Section B of the statute. And that section, let's see, sorry. This is how it reads. The Supreme Court shall establish guidelines for determining and awarding spousal maintenance. The court may award spousal maintenance pursuant to the guidelines only for a period of time and an amount necessary to enable the receiving spouse to become self-sufficient. The amount of spousal maintenance resulting from the application of the guidelines shall be the amount of spousal maintenance ordered by the court, unless the court finds in writing that applying the guidelines would be inappropriate or unjust. So this is, applicable to when the guidelines come out. There is a subcommittee that's been put together under the Family Court Improvement Committee. It's made up of judges, attorneys. There's a vocational expert there, and then there's also, I believe, a CPA. And they are broken down into these work groups. Let me pull this right here. They're broken down into work groups under the subcommittee to come up with, let me pull this, I have the wrong document.
Kelly, when you have it, I'm so sorry. I just wanted to say there is somebody I think that has a question. Jessica, when you're ready for it.
Oh, sorry, I forgot the Lord's hand.
Oh.
That's all right. Okay. Sorry. Go ahead.
So under the Family Court Improvement Committee, they did a subcommittee to put the spousal maintenance guidelines to put the proposal together. And under the subcommittee structure are work groups, and the work groups are for assets, deviations, duration, income, self-sufficiency, and temporary orders. Let me get over to this. Oh, there's one more part on this I want to put. So I have like a proposal that came out a while ago. I was gonna see if either it could be shared with everybody or if it could be on the Supreme Court website under the groups that they have under the Family Court Improvement Committee. It might just be right there, and I will do what I can to get that out to Don so he can get it out to you. And the other thing is going forward, in February, there is a meeting to go over the current proposal. And even from Judge Cohen, when he put out this information, the draft, I'm assuming, is what they're going to be going over at this upcoming meeting in February. And then the proposal will go through public comment. So you're all welcome to comment on that at the time. And then it'll be voted by the Supreme Court. And I did hear June of this year. So the likely effective date is going to be January. This time next year, it looks like we're going to have the spousal maintenance guidelines in place. And there's not too much more I know about it. One of the things that Judge Cohen did state is, which I don't think is going to affect document preparers as much as it's going to really affect attorneys. Like, where are they on this? Since it's stressing this self-sufficiency thing. The Judge Cohen said each case will be decided on its facts. In doing so, however, the new public policy must be applied as of September 24, 2022. The word only has a significant policy implication. In fact, this is the subject of an emergency order that came out from our Chief Justice in the Supreme Court, and that was issued on September 22nd. And that's something also I can give to I can give that to Don to email out, because that's something you can go look up. But basically, just to kind of highlight it, it's the administrative order is basically saying that effective as of September 24, 2022, and until the court's adoption of the spousal maintenance guidelines or further orders of this court, judges determining a maintenance award for either spousal maintenance in a proceeding governed by ARS 25-319. I don't know why he says either. Oh, for either spouse in a proceeding, sorry. Governed by 25-319. And there's just 5 numbered paragraphs here. It says, may grant a maintenance order only if the court finds the spouse seeking maintenance satisfies one of the criteria set forth in 25-319A. I think you guys are familiar with those, the ones that are in family court. It may also award spousal maintenance only for a period of time necessary and an amount necessary to enable the receiving spouse to become self-sufficient. They're really self-sufficient, I think, is the key here. It must address the factors in 25-319B 1 through 13. So the factors that they have to list their findings underneath in the ruling, and must make any maintenance award without regard to marital misconduct. I mean, that's pretty much the same, and should apply the body of case law interpreting the pre-amendment factors set forth in ARS 25-319, which is I don't really think comes to us. I mean, people should be getting that from attorneys, but how case law is affecting the interpretation of the statute, and probably this new change as well. But I don't know if we have case law out on it yet. And that's pretty much all I know. What I can do going forward is any updates that come out, I'm happy to provide them to Don to disperse to everybody. But if anybody else knows anything they want to add in, that's what I know about the spousal maintenance guidelines that are in our near future.
Okay.
Okay.
Terrific.
So this is just a minor update on child support. There is pretty minor. One of the main things that I just want to point out that I think is the thing that I'm pretty sure anyone in family court knows this, but this year the minimum wage is $13.85. It went up January 1st, and that does affect, of course, the calculation of child support. So basically, that's about $2,400 a month for gross. And when you have people saying I only make $2,100, you're like, well, then you have to explain to them the guidelines and the requirement for most cases of minimum wage. But that's the main thing. Some of the minor corrections, I just pulled this from something from the Family Court Improvement Committee. There were some minor changes. Pull this back. This one right here, see, there's a correlation table. There were some corrections there. It was the correlation table that showed you, what changes had been made in the guidelines in 2022, how it correlated because they had restructured some of it. It's a pretty minor change. I guess it was the example, and I don't know if anyone's even used this yet, but one of the changes in the 2022 guidelines, where someone had a very low income and they had other children, pretty much any children coming after that got no child support at all. This was a way that they put in a process into place, which is a little bit complicated, but they put a process into place where all children are treated equally with or without a court order. And then some child support would come from there. So they kind of divided up among the children instead of just whoever got there first gets the child support, and any kids after that, there's just no money to be had kind of thing. But if you do encounter a case like that, you definitely want to go to the guidelines and see the what's in the guidelines, and then they have a lot of examples in there to help you understand it. There were some mathematical corrections. This one was, according to this, it was done, it said, as currently written, does not consider the adjustment for children over age 12. I wasn't aware of that, so I was a little not clear on this. And the correction that they did is supposed to help self-represented litigants achieve a more accurate estimate of the child support amount, and with judges in explaining why judges or commissioners explaining why there may be child support ordered in situations where there's equal parenting time, equal income case, and an older child. If anyone has anything to add to that, please do. And then the rest of this is pretty much technical corrections. One of the things, if you have not noticed, is in the new guidelines, they don't say gross income, they say child support income. That was one of the language changes they made. And I was curious, might as well ask now, is there anyone that has seen anything else that needs to be corrected with the worksheet calculation in the guidelines? What comes out in the child support order? If you see anything, let me know. Let Dawn know, and then we can, let Susan Pickert know, who is in charge of taking care of corrections and proposing them for them to be amended. Okay. Do you have any questions, Dawn?
Nope, not right now.
This I'm just going to touch on briefly. There was a lot of changes to orders of protection, the rules and statutes and stuff. I didn't delve into this one. The one thing I wanted to point out that if you do not know already, I think is helpful to know in family court, but there is now a 2-year term on orders of protection instead of a 1-year term. And these words are from Judge Cohen as well. All orders of protection that are served, not issued, shall be effective for a 2-year term, not a 1-year term. That took place in September of last year, regardless of the date in which the ex parte order of protection was issued. Service of process is the trigger. I just think that's important to know in family court, because we we see a lot of people getting orders of protection. I'm going to have some people ask questions or something, because this
Yeah,
part I'm just going to breeze through.
There is a question. Angelica asked, how much is the minimum wage for child support purposes?
It's $13.85. It's whatever Arizona is. It's like Arizona or federal or whichever one's higher. I don't remember. I haven't even looked at that in years, but we always go by the Arizona minimum wage, which is currently $13.85, and that's what the court's going to go with as well, unless they have some reason to change the court's mind on that. But it's $13.85 for this year. It looks like it's going to be changing again, because that specifically said from January 1st until the end of this year.
Okay, thank you.
Mm-hmm. Okay.
All right.
This is not going to take very long, so it looks like I still have like 25 minutes left.
That's okay.
These are just some additional updates. Temporary orders, the assigned temporary orders issues its own statute now. It didn't previously have one. This is on 76B, 34B. This is about the obligation of parties to consult with one another in connection with certain pretrial proceedings. And basically, if you read it, I have these listed, you can go look them up. But basically, if you read the 76B, the 34B more has to do with like conflicts with attorney's schedule, but 76B is just talking about conferring for like, I think it's resolution management conference. And I think what they were trying to clarify in this is the domestic violence aspect of it, that if there's a party that's not represented and there's been domestic violence, they're not required to have to go and talk to that person that, you know, they were abused by or whatever the situation is.
And then there's at least one judge, you know, maybe a couple of them that do make part of their orders to go to some conferences, like certain like open negotiation conferences, for example, will require the parties to communicate ahead of time and exchange specific proposals, as well as require them to evaluate the proposal offered by the other party in a particular way, and maybe even comment about the other party, you know, maybe some positive aspects either before or now. Before is, I know it's kind of vague, but about what the other party brings to the, you know, to the table in terms of being a co-parent or being a parent for their children. And in any ways to exchange this type of information before they go to the conference, so they have more of a more clarity about where each other is coming from, so they maybe go into it with a mindset of more of a positive mindset about their co-parent, about you know, how they are as a parent, what positive aspects or positive things they bring as a co-parent to the child and to the co-parent relationship. I don't think these are any court rules, but the judges, they do talk about these things, and I know one or two of the judges actually puts those into the orders for open negotiations at least.
So how do they handle how is, I know the early resolution conferences right now, my understanding is they're virtual. The stuff that the things you're doing, like the parenting conference and the open negotiations, are they in person?
So currently in conciliation services, in-person services are parenting conferences and mediations, and then child interviews. And then conciliations, as well as open negotiations, are remote, are through Microsoft Teams. But my understanding is that very soon mediations will go back to remote conferences as well. Now, people can petition, they can ask for in-person conferences, for a conference to be in person, or on the flip side, if something's always in person, if there's something going on and there's a good reason that it should be remote, they can ask for that as well. But that's the status right now. As I said, my understanding is sometime in the near future, the mediations are going to go back to being remote.
So, Don, how do you guys handle when there's an order of protection and you have two people representing themselves?
It really depends. It depends. It by definition, it doesn't disqualify parties from participating in an in-person conference at all. But when parties come into conciliation services, they fill out an intake form, and there are various questions on there that indicate whether or not what's been going on in the past and the present. In terms of maybe domestic violence, or if there's an order of protection in place, or something else, and then whether or not a party is concerned or afraid to participate in the conference. And so if there's an indication, whether or not there's an order of protection in place, there's an indication that a party is not comfortable or afraid to participate in a conference, then the conciliator should meet with the parties individually to kind of explore that. But I would say that, I don't think a conciliator is going to ever, force somebody to meet face to face, or not face to face, but in the same room, in a conference, if it's inappropriate. And a conference can be determined to be inappropriate. I'll tell you in my experience, even the vast majority of situations where people might indicate on paper that they're concerned or afraid, probably the majority of them go ahead and do it, and it turns out fine. But there are other options too, that parties can be put in different rooms. There can be other accommodations made that may make people feel more comfortable. But generally speaking, if there's a situation where a party feels that they cannot meaningfully participate in a conference because of these, because of the circumstances, or that, or that somebody may be, either the party or the children may be retaliated against in some way because of what they may be saying during the conference, then that's probably not an appropriate conference. Does that make sense?
Yeah. What do you think about the order of protections going from 1 year to 2 years?
Yeah, I don't know really anything behind that as for what the rationale was for extending that. I don't I don't know. Not that my opinion matters. It doesn't really matter, and with that. But I my inclination is to say I don't think it's a good idea. I think that people should just have to. I mean, it's not usually going to be a problem to get it renewed. 2 years seems like an awfully long time. But again, I don't know the studies underneath it. The basis that decision was made. But and I just think things can change a lot in a year, and if it needs to be extended, they can go back and petition to extend it. But maybe there's I imagine there's some good reasons behind why it was extended to a 2-year time frame. But as you're probably aware, and those of you that practice family law, that can orders of protection, while they're necessary. I think sometimes they can be ordered when maybe they're not so necessary, or it can become not so necessarily necessary, and it can really wreak havoc on facilitating parenting time and decision making and communication that needs to take place. But when I say that, I'm in no way minimizing the absolute necessity of having them in certain situations, but it can make things problematic.
Right. Well, also when children are put on there and they're not going to see their children for 2 years.
Yeah. Well, and as you're probably aware, I mean, that while that it's not unusual for something like that to happen, um, usually, um, that can be that can be modified. Unless the children do need to be protected.
Mhm.
But often, in my experience, often when children are added to orders of protection that are really intended to protect the parent, and not necessarily the child, that usually can be resolved by requesting a hearing, and kind of dealing with that aspect of it.
Yeah. Um, the only other thing I really have left on this is, I can get this to move. Oops.
And there are a couple of questions in the chat
Okay.
too, I think I can read to you. So let's see. Barry Goldman asked, with regard to ordered protections, process servers can't charge, I guess this is kind of informative, cannot charge a fee for services of the orders of protections involving a dating or sexual relationship. Hopefully I read that correctly. And then Norm Thomas asked a question, can orders of protection be modified or withdrawn? And
Don?
yeah, they can. Yeah. Who is that, Barry?
This is Barry. Yeah.
Right, go ahead, Barry.
I've been a process server since 1987, and we served several orders of protection, but we have to serve them pro bono. And any injunctions against harassment involving a dating or sexual relationship, such as rape or molestation, they have to be served without fee as well. So if you get a process server who will serve an order of protection for a fee, you got the wrong process server. They are subject to disciplinary action before the Supreme Court.
No, that's good information. How does that relate to, and obviously if you have multiple documents to serve, you can charge for the other documents, you just can't charge for that.
That is correct.
Okay.
Yeah.
Okay, thank you, Barry. That's good information. Another question from Angelica. If a waitress or another type of worker makes less than the minimum wage of $13.85, how does it work? The $13.85 must be in, how does that work in calculating it?
I think overall, under the guidelines, everyone, they presume for the most part that anyone's capable of getting a minimum wage job at full time. So when you put in the 1385, it calculates at 40 hours a week. And there can be exceptions from that, but typically that's going to be a judge or a commissioner making that decision. But that's generally how it's approached, is that anyone could get a 40-hour-a-week job paying the minimum wage.
Okay, does that answer your question, Angelica? All right. Any other questions or comments on the information that that she's gone over so far? I know we're almost wrapping it up. Patricia asked, what if a person receives Social Security disability income? Would we still put in minimum wage?
No. Under the guidelines, you would go by what they're receiving in disability. You just have to look at the guidelines because there's, it really breaks down what income is and how it's included. But, the minimum wage thing comes up often because many people say, I only make $2,000 a month. I'm like, well, you got to at least go by minimum wage unless you have a valid reason. But I would think on most agreements, if you don't put minimum wage, you need to put some kind of explanation somewhere in the stipulation or agreement as to why you're not going by the minimum wage, because it could be an issue for a judicial officer.
Well, can you shed any light on deviations? Like how over time, I've done family law work since the early mid 90s, and over time I've seen hills and valleys with, the judicial officers being willing to order, even agreed upon or maybe even not agreed upon deviations from the child support guidelines. What's your experience with that right now? Is there flexibility, or is it only under certain specific circumstances? Or, like, for example, I mean, over the years, I've seen situations where maybe even the same situation where parties absolutely agreed in a consent decree to deviate from, a certain amount to zero. And let's say in 1999, that would be no problem. And in 2010, there's no way.
Mm-hmm. I know what you're talking about. Right now, deviations where parties agree, they're primarily going with those. It's only once in a great while I see an issue with that, where a judge might question something, but it's not very often over the last few or more years. Pretty much if the parties are in agreement, then the court seems to go with it on consent decrees and, agreements to modify child support, that kind of thing. On defaults, when I'm working with someone that wants to do something outside the guidelines, deviate or change how they're going to claim the kids as exemptions for taxes, or how they're going to be responsible for anything not covered by insurance, I just let them know that, this is a default. The other party's not involved. Commissioners do seem to have a tendency to go with the guidelines, but they can let some stuff through if they think it's fair. But it's up to the judicial officer at that point. So I just let them know that they might not get what they're asking for when it comes to that. Outside that, in the courtrooms, I mean, I know judges do deviations for different reasons, but outside reading orders, I'm not in the courtroom and not seeing what's going on in the situation anyway, so I wouldn't know really what's going on there. But under agreements, even right now, judges seem, and one of the things I've seen over the years is when the parties decide they don't want to have an income withholding order, and they just want to Venmo each other or whatever. There was like 5 or 6 years ago, I had 2 judges completely disregard that. And we filed a motion for each case. We filed a motion. It was different judges. They totally disregarded the motions. And then I was afraid to do that. And then in the last few years, I haven't had one issue with it, with people wanting to do direct payments for spousal or child support.
Okay. Another question from Rosemary. With the summary consent, do you need to file a motion/order for no hearing, or is it implied or part of the summary consent decree?
It's not required. It's according to the statute, it's the judge or a floating commissioner. It's the judicial officer that can make a decision to set a hearing. But that's always been there with consent decrees, and you don't really see them hardly ever. So it's just the same.
Okay. All right. I think we're almost ready to wrap this segment up, and then we'll move into our last segment, which is the ethics hour. But anybody have any other questions or comments about this great material that Kelly has gone over? So Kelly, go ahead, and if you got I think just a couple, one or two things to wrap up.
One more, and I can't get to it, but it's very simple. I'll just read it, and then it'll be in the materials. Rules 78 and 91 of the Arizona Rules of Family Law Procedure was amended to better define, in quotations, judgment and clarify when post-judgment rulings are appealable. And one thing I saw last on this is that they may be doing further modifications to it. But I think it's just a change in language to better clarify when the appeal time starts on a judgment.
Okay. Okay.
That's my dog. I'm sorry.
Yeah. No. All right. So we thank you.
One more thing I want to add.
Is that it, Kelly? Or okay.
I just have one more thing. I just want to let everybody know that I've heard that Judge Cohen I think he's rotating But June, we will no longer have Judge Cohen. I don't know who is replacing him as the family court presiding judge. Do you, Don?
Yes, but I'm forgetting off the top of my head.
Oh, okay.
I'm sorry. I
But
can't remember.
for me personally, and I think maybe other people that's attending as well, he's been one of the most amazing presiding judges I've ever seen. He has made so many changes in family court with the summary consent decree process, the termination of legal separations, the changes. He was so a part of the changes to the child support guidelines. He's been he's done so much for family law. It just, boggles me how much he's done, and I'm so grateful, and I'm really sad about him leaving. I think he's one of the best judges and family law, person I've ever experienced out there. He's an amazing judge.
Absolutely. Yeah. And as Patricia said in the comments, he's been a big supporter of LDPs as well. And that's been very important.
Yeah, he is. And it's refreshing to have something like that. Someone that feels
I don't know. I don't recall where he's going, but I hope and I imagine we'll be able to get him back in the future to speak. I think he spoke exactly a year ago in our webinar, and he's so open and willing and available to do those kind of things. And yeah, we really appreciate it.
For the spousal maintenance guidelines.
Yeah.
Because he's on that committee. He's on that subcommittee.
Absolutely. Okay. So anything else, Kelly?
That's it for me.
Okay. Yeah, and I guess I'm trying to think if there's any other changes that I'm aware of. The only other updates or changes or things most of you probably don't get involved with, but with your clients in family law. But I know there's some, the PIP class, the parent information class. I think the providers the providers are changing. I think the online program is one done by the court now. That's going to be offered. I don't think that's happened exactly yet, but my understanding is that's what's going on. And then there's and I forget what this stands for, but there's you probably know about the high conflict resolution class that the court offers. There's now going to be a similar online version. They call it FIT. We're just kind of we're doing just kind of a sampling of it right now to get feedback from attendees, really about both that and the in-person class. And so it's good to know about those things. If any of you don't know about the high conflict resolution class, I'm typically the vast majority of people that attend it are court ordered to attend. It's a 4-hour class that goes over just everything from underlying reasons that people have high conflict to how they engage in high conflict to the impact that high parental conflict has on the parties themselves as well as the children, and then kind of a review of some strategies that you can engage in to hopefully reduce or eliminate high parental conflict. It can be very valuable for some folks. As you can imagine, some folks just aren't going to change or aren't interested in changing no matter what. But I understand the FIT program, the new one that's online. And people can find out about it if they call to schedule if they're court ordered or they just want to attend the class, they can. I guess that was my ultimate point, is that people can voluntarily attend, and that happens sometimes. But whether they voluntarily attend or they're court ordered, I at least right now, I think they can request to be part of the initial group that does the online program, and that was developed by kind of a joint effort, mostly by ASU psychology department with the court. And ASU is working on a lot, several different programs for high conflict parents, for children that are subjected to high conflict, in coping. it's definitely something to look into if you have clients that have those kind of issues. And I don't know about you all, I've had many clients that have had serious issues with high conflict that really inhibits their ability to have much of a meaningful co-parenting existence and just makes their life absolutely miserable in many respects. So that's all I got for an update. And so it's exactly 12 noon. What great timing, huh? And so we're going to move on to our final presentation of the day, which is with Alan Merrill. Alan, so I need to, let's see, I need to unspotlight Kelly and put the spotlight on Alan. Give me just a second to do that if you want to take a brief break while we're figuring that out. Just take a minute. All right. Okay, Alan, are you there?
I'm here.
You are there. All right. And so Alan does not have a PowerPoint that he's going to be sharing with everybody. However, he has an outline that we can kind of follow. I'm going to see, Alan, if I can just share that page with the outline that people can follow along with without messing with without interfering with whatever you're doing. So bear with me for just a second, and we'll see if I can share that. Okay. So can you see the outline that I put up?
Yeah.
Okay. All right. All right. So now, Alan, before you get started, so Alan's doing the ethics hour. I also, and I don't think I'm going to be interfering with anything you're going to say. I just wanted to make a quick comment on, as far as the legal document preparer program update. As most of you are probably aware, we've been kind of dealing with for the last couple years the possibility that there's going to be a significant rules change that would impact, certain types of forms or documents that we could do, like, anything that references some primary authority in the law, like a motion or various types of pleading. And so there were some proposals, some rules change proposals. I think lastly, in the last year, not quite a year ago, and many of us submitted public comment, and then it just kind of stopped. It just kind of the process just kind of halted, and I just wanted to say that I've inquired about the issue. There's nothing, that is currently planned, but I know these things are kind of sprung upon us, without much of a warning. But I've been making attempts to keep in contact with the people at the program, since that happened. So maybe we have a little more of a heads up. Maybe we can be given an opportunity to make proposals of our own that might deal with whatever their concerns are. For example, a lot of the concern having to do with us preparing documents that cited primary authority, like, statutes, case law, and whatnot, or just doing types of documents, those types of documents, motions. My suggestion to the program was to deal with it in the form of disclosures to consumers. And it's always been my opinion that consumers can make the decision whether they want to utilize documents that we prepare that cite certain type of authority, knowing that it's not necessarily the only way to approach things, it's not necessarily the best way to approach things, but it is an accurate document. I think that that particular proposal, which I won't go into detail right now, had a little to do with, at least putting a temporary stop on whatever they were doing, but there's nothing going on since then. And I have requested, back in November, I requested Aaron Nash with the program and who oversees it, to if you would be interested in either himself or someone from his staff presenting during one or more of our ethics hours this season. And he indicated that he was very interested in doing that, and but at the time was just kind of busy and not sure, which classes that he could attend. I have sent some follow-up request recently, and hopefully that he'll be willing to do that maybe in February or March or April. So I'm hoping that that happens, so we can be a little more informed about what they're thinking and what's going on with the program. So, but that's all I have as far as a program update with the LDP program. So I'll turn it over to Alan.
Okay. Good morning. Along those lines, I think the fact that Aaron Nash is the staff attorney has had some effect on this lesser reasons for changing these things or putting more restrictions out. The former staff attorney was pretty well dead set on making sure nobody could be even close to being an attorney or close to doing things that an attorney would do. And he really didn't follow the rule 7-208 very well. So anyway, that's irrelevant at this point. We're going to go through a few of the basics, and I'm sure most of you already know them, but we're going to go through a few things, and then if we have time, I'm going to throw out a few situations and ask you to make comments on how you would handle them. The first one is the code of conduct, which is found in section K of rule 7-208. And if you have not read this, I think it's important to do that and kind of keep up on it, because this is the whole basis for determining whether we are practicing ethical things and whether we have handled our business in the way that we should. And so it is section K of 7-208, and it's easy to get. If you don't have it, you just go on to the Supreme Court website and go to the licensing and regulations, and there it is. And go to LDP, to legal document prepare. And so yeah, okay. So Don's putting up putting that up right now.
Section K.
Section K. Mm-hmm. So while he's doing that, let's talk about ethics. And I don't want to go through a lot of complicated descriptions, which we have here in one, ethics. But it is important to kind of understand what the program is trying to do. And then most of us could probably give these same this documentary in about 2 sentences. So, but let's go through for it. And I think there's a few important things. I'm sorry to be wiping my nose all the time. I'm an old man, and I'm have a little trouble with that. Under A legal document preparer shall avoid impropriety and the appearance of impropriety in all activities, and shall obey the laws and so forth. So what is the what would you say is the idea of impropriety? Uh, that's sort of a iffy type of thing. I think we all know what's illegal, but the question is what's impropriety, and I think that that's essentially what it means to you and what generally society is uh, uh, looks at it. And so it says that legal document preparer shall be alert to situations that are conflicts of interest or may give the appearance of conflicts of interest. We're going to have a few questions about that a little bit later on, and you can actually answer what you think. And full disclosure, another issue, and C is making full disclosure. And D, which is something that comes up over and over again in 7-208. A legal document preparer shall refrain from knowingly making misleading, deceptive, untrue, or fraudulent representations while assisting a consumer in the preparation of legal documents, and shall not engage in unethical or unprofessional conduct in any professional dealings. There are similar requirements for lawyers, and I think that's probably where most this kind of wording came from. So we and ethics may sound like kind of a boring subject to you, and I guess it would be to most people. But the reason for that is, and maybe the justification and the reason that it's a good thing is that disciplinary actions by the Board of Legal Document Preparers, I guess they don't call it that now, it's the Board of something else. Most of them are based on ethics, a violation of ethics or professionalism, which we're going to get to next. So you want to read that and be careful about it and understand it. We can't just do anything that we want to do or what we may think might be even beneficial to our client. In the second section, on professionalism, it says that we have to treat the information that we get as confidential and yet not be privileged. And so I'm sure most of you recognize the difference of that. And I don't know whether you use an intake form, but in our case, we have all clients sign an intake form where they are, that very statement is stated in there, and they recognize it and accept it, that the information they give us is confidential, but not privileged. And so, and we define that and say that confidential can be, we would keep it and not voluntarily release their information, but we could be subpoenaed for that information. If lawyers and CPAs and some others who get privileged information, they cannot be subpoenaed for the information. So that's professionalism. The next step on this area is fees and services, and the fees. In the early days, there was a concern that there might be an effort on the part of all the document preparers to come together and create a fee schedule. And that, I think that's where this kind of came up too, because you have to understand that before the certification program came into being in 2002, that for probably almost 20 years before that, there had been legal document preparers or independent paralegals, as we called ourselves. And so there were some concerns about different practices or things that they thought might be happening. The court thought might be happening. And I doubt that. True. My experience is that document preparers have been very, very competitive when it comes to fees and practices even. And so it doesn't seem to me like it's one of those things that the Board of Certified Document Preparers needs to worry about. But in that, they're saying that we don't set the fees together. So, and also there's another issue that comes up. We cannot have a fee that is a percentage of an outcome. So if you have circumstances where you are going to, say, handle real estate documents for a sale or something like that, and you can't set your fees on a percentage of the outcome there. And now you can set your fees on an hourly basis if you want to, or whatever you want, or even flat fees. And so then the next category that I'm concerned about, or that I think is very important for us, is called skills and practice.
Hey, Alan.
And
Alan,
yeah.
before you go on to that, I just wanted to, I'm sorry, I was doing something else for a minute. I should have spoken up earlier, but you were asking originally about, the ethics issues with avoiding impropriety, the appearance of impropriety. And I just wanted to comment on that, and maybe even relate it to some of the materials that we've gone over today. And I think the biggest pitfall for document preparers is really having to do with language, and having to, having the ability to phrase things in such a way that you're not making recommendations, that you're not representing that you know more, or you're more qualified than you are, and for that, or even if you are very qualified, that should be a basis for them taking a particular action. So in other words, saying, in response to a question, let's say, how to proceed in a divorce action, whether you're going to file a petition or whether it's in their best interest to do the abbreviated consent process, responding to a client and saying, that's what I would do, or you should do this, or, hey, I've been doing this for 30 years and that's what, that's the best course of action. I've experienced, and it's always worked out that way. Or, in a litigation, like maybe in some of the um, some of the material that Brian Locker went over with us today, making a recommendation that that's the course of action that you should go if you have a dispute over title to a property, or in deeds, making a recommendation that, yeah, you're better off doing a community property deed, or, versus a joint tenancy deed, or, for estate planning, using a beneficiary deed rather than a trust, or the other way around. This is where I think we cross the line in the use of language that that makes recommendations, that it makes it appear that they should follow our advice on a particular matter. It's in phrasing, and I'm sure, and maybe some of you might want to speak up and talk about how you phrase things when people are asking questions about what they should or should not do.
I agree with that, and I do think that there's a lot of document preparers that are very, very knowledgeable, and they may even know more than lawyers. The problem is you cannot say that, or say that to a client, or give them impressions about things, because in fact you're not allowed to. The idea of advice is a very broad concept in these issues, and so we have to be very careful that we don't infer things. We can't really infer that we know more than the lawyer, or know more on a particular case like this. I had a situation a number of years ago, and it was one reason I brought a question up for Brian Locker about this Arizona statute that he was referring to. And it was probably 10 years ago. I had a couple come in, and the wife said that her great grandparents had some property in Texas, and they died, and it just nothing was ever done. They never had probates. It went through. She said it went through the other descendants, but actually there was no evidence of that. There was no deeds. There was no probate. No nothing. And so now there's about 20 descendants of those great grandparents, and this woman had been paying all the taxes on the property. Nobody else would pay the taxes. So she was of the opinion that since she's the only one who's willing to pay the taxes, that she ought to be the owner of the property. And she was a descendant. And so she said, how are we going to do this? And I said, well, I don't know, because I don't know anything about Texas, but other than going through probates on all these people along the way that have died, all these descendants that have died, even then, I don't know whether that would resolve it. And I said, I suggested to her that you may want to talk to a lawyer about it. And she said, well, we have. And they think we should do a quiet title action. And but the lawyer in Texas has to be done in Texas, and the lawyer in Texas wants to charge an immense amount of money to do it. And so in the end, I said, well, I can draw up the petition, and you can present it to the court if you want to. You'll probably have to take it over there and do it. And I can't guarantee anything. I don't know whether it's right or wrong. And so she gave me the information and gave me the names of all the people that she knew of that were living descendants, and names and addresses. So she went ahead and did it, and it dragged on for a couple of years, and the court required us to do a publication, which was interesting because it was like $700 for the publication in this little town in southwest Texas. And then the people that we had to have process servers serve them. And so that was another $700 or $800. And in the end, it's kind of interesting because in the end, the judge got that all together and gave her the property. And so the question would be, how close did I come to giving her legal advice? And I told her that, I can't tell you what to do. All I can tell you what you can, what your options are. But since she had already talked to an attorney and gotten kind of the ideas, I felt fairly comfortable with it. So the big question, it was a Texas court. Somebody's asking whether it was a Texas court or Arizona. Yeah, it was in Texas, and down in some tiny little town and county in Texas. And so it took a couple of years, maybe even 2.5 years, but it finally, they came by our office and said, hey, we're on our way to Texas to a hearing. We hope this all works out. And they got there, and they called me the next day and said the judge signed it and deeded the property. We own the property now, or she does, the wife did. So anyway, there's all kinds of things that can come up if you are, unless you are restricting your practice to, family law or other things. Even then, it's very easy to, if you're knowledgeable, and I think most document preparers are, if you're knowledgeable, it's very easy to want to help people and to give them direction and so forth. But we have to be very, very careful that we don't tell them what to do. In 7-208, it says that we can tell them their options, but we cannot say which options they should select. So those are some of the things that that we talk about in the ethics and in professionalism.
Alan,
Uh,
there was another question from
Okay.
Patricia. Her question is, other than bankruptcy, does anyone know of any other rule, law, regulation that caps LDP fees?
I don't know of any um, that are official anyway. Um, that's the only one that I know of, and that's actually one reason why I don't do bankruptcies, or we stopped doing bankruptcies 15 years ago. Was because they put a cap on it that we felt, and because the bankruptcy abuse law, which was passed in 2006 or 5 or 6, made it created some risks that we were unwilling to accept. And $200, I don't know whether it's $200 still.
Yeah, well, it's a good thing, and this is sarcasm I'm displaying here. It's a good thing the cost of living has never gone up, since
That's right.
2005, so we didn't need to raise our fees.
Yeah, it's it's a pretty ridiculous amount of money for what has to be done in bankruptcies. But I don't know, to answer the question, I do not know of any other restrictions on it. I know document preparers that charge pretty significant fees and some that are super reasonable. So it's a very competitive business, as you all know, probably. And so I don't know that the fee issue is such an issue to be concerned about. We just need to make sure that we don't um, charge percentages or charge a fee based on the end results of what we're doing. And that's and we can have other people. We can have associates doing other work. It says a legal document preparer may consult, associate, collaborate with, and involve other professionals. So to assist the consumer, and obviously they can charge fees. So I really don't. My concern isn't so much in fees. I think we handle fees pretty well as a group. The skills and practice is an area where I think that there's a lot of exposure, perhaps. One of the very first statements under K4A is a legal document preparer shall provide completed documents to a consumer in a timely manner. And I don't know about you, but I know when I was doing this, it was sometimes very difficult to do that. Clients didn't provide all the information. You call them and they don't get around to it. And then they call you 3 weeks later or 4 weeks later and say, how come my documents aren't done? Well, because you still haven't provided us with the information. So we have to be a little bit careful about those kinds of things. We have to make a good faith effort that says, and but the next one on B is one that I think is also important, and I have a question about it. A legal document preparer shall accept only those assignments for which the legal document preparer's level of competence will result in the preparation of an accurate document. So that's the question on the little outline that I gave you. Doesn't this require competency? And it does. It does require competency. And it says the preparation of an accurate document. So that actually is an issue that has really become, in some efforts to discipline document preparers, has been an issue, because the definition of an accurate document, sometimes in those accurate documents, it requires citing a statute or citing perhaps even case law or other things. And that's where the previous staff attorney seemed to be very concerned. He considered that to be the practice of law, which the truth is we are licensed or certified to practice law under Rule 31. That's exactly what we're doing. The only difference is we have a very we have a limited practice of it. And but he was very worried about anybody interpreting what we do as practicing law. And so this business, the level of competence. So the question I have for you, and anybody can answer this if you want to, is how do you get the level of competence in a document? I mean, obviously you can go on maybe like, especially in family law, but other things too. You can go on the website and the self-help websites. But if it's a document that's not on there, how do you become competent in those types of documents without doing them without the competence before you have the competence? So if you have a comment on that, I'd be interested in hearing it. My personal opinion is that your level of competence increases by study and increases by looking at other similar situations and documents. And you just generally cannot guarantee that on a new document that you haven't done before, a similar type of document, that you know that you have that competence. You have to build it, and you have to be careful especially careful at that point about how to do it. So the wording of this requirement is accept only assignments for which the legal document preparer's level of competence will result in the preparation. So the level of competence also includes how competent you are at researching those documents and researching certain situations. And the more documents you do, the older you get, the more of these things you kind of run into. And so it says the document preparer shall decline an assignment where the legal document preparer's ability are inadequate for that assignment. So how many of us have declined assignments? I would guess every single one of us has declined an assignment at some point or another that we don't feel comfortable in the terms of our knowledge of doing. And that is important. I mean, everybody wants to make money, and there's a temptation to accept everything that comes in the door. But usually those things that we have a low level of understanding of are probably more work than they're worth in terms of the money for us. So, Scott, you want to comment on that? You said declining an assignment is the most humble and ethical decision. I can't read the rest of the commentary.
I said one can make. Yeah, I mean, I hear document preparers that I don't personally work with, but that they forget to put their ego down quite frequently and want to try to make the money rather than be an ethical document preparer. That's where my thought was coming from.
Sure, I agree with that. And somebody else had a comment I didn't catch here. Yeah, okay.
It's the other comment is maybe I misunderstood, but I want to confirm if a CLDP can also charge to clients by the hour.
Yeah, I see no reason to not to do that. And certainly, for instance, if you you do not have to have set fees per document. No, there's nothing in 7-208 or any other rules of the court that require you to do that. Because obviously let's say some divorce documents are similar or easy. Others are tremendously more complicated. And so you can charge by the hour. You cannot charge by, in fact, here's exactly what it says. You can't establish contingent fees as a basis of compensation. So it can't be a percentage or contingent upon certain results. You cannot accept directly or indirectly receiving of any gift, incentive, reward, or anything of value as a condition of the performance of professional services. And you cannot directly or indirectly offer to pay any commission or other condition in order to secure those professional assignments. So you cannot say, okay, if you come and do your trust with us, we will give you a little fee, or we will do this or do that. I've had numerous estate planners over the years, 35 years I've been doing this, come and want to kind of send me business and so forth. But in exchange, they get a percentage of the fee or something like that. That is absolutely untenable and unallowed. However, you can charge hourly. You can charge by the document. Those are legitimate ways of asking, and they don't result. They're not as a result of what you're going to do. That's your performance on those documents is one of those things that's talked about in skills and practice. You must be able to perform those documents properly. So it doesn't make any difference if you're getting a big fee or a little fee. You have to do that. So you can charge hourly, and you can charge by the document. Any way that is not contingent upon a certain result. Don, did you want to say something?
Yeah, just to confirm what you're saying, and also maybe to offer some perspective. Clearly the rule says that we shall determine fees independently, period. But I think there may be a presumption sometimes that charging an hourly rate is just a way of charging more money. And I don't think that's the case at all. And I'll give you a couple examples. Let's say, whether or not you typically charge flat rates. Let's say you regularly do, but you're taking in, let's say, a divorce where people have a large amount of property that you're dealing with, and that divorce, and so that includes itemizing the property and debts that are maybe in the pleadings, as well as maybe preparing a large number of deeds, for example. You may decide that, hey, my flat fee does not cut it here, and at least my regular flat fee, and it would be more of a fair situation to charge an hourly rate. On the flip side of that, or on the same note, let's say that you charge an hourly rate to do or a flat fee to do a deed. Let's say it's $75, but somebody is coming to you with 15 deeds. And for many of them, it's a lot of the same information. Their name and address is all the same. There's a lot of things that are very similar. It's going to the same people. So maybe it's more of a fair thing to charge an hourly rate, which may end up being significantly less than the flat rate that you would normally charge for a particular deed. I'm just saying that I think it's a fair consideration in either direction that may make you more than you normally charge for a particular service, or maybe less for a particular service. But I guess the bottom line is that we can charge fees independently. We can determine our fees independently.
Yeah, and I agree with all of that. Everybody is going to run into some situations that require a whale of a lot more time than you expected. And so the question is, do you charge more for that, or do you just eat it and go ahead and charge a standard rate? Rob, in one of the earlier classes, commented that when a client he was doing, say, a divorce for, and they came back in and want to make changes and so forth, and he charges extra. And I think most people do charge extra for them to kind of do that. We do trusts. People come in later on and change that. We charge them for it. This is a business like any other business, and you can charge based on your effort that you put forth or your knowledge, additional knowledge that you do. The only problem is you cannot charge based on an outcome, on the results. You cannot hinge your fee to the outcome. So, that's that. The performance in accordance with the law seems like a no-brainer to me. It says the legal document preparer shall perform all duties and discharge all obligations in accordance with applicable laws, rules, or court orders. I would hope so. Pardon me. And then it goes on to, and the big thing that is concerning the Supreme Court is a legal document preparer shall not represent that they are authorized to practice law in this state, or shall the legal document preparer provide legal advice or services to another by expressing opinions, either verbal or written, or by representing another in a judicial, quasi-judicial, or administrative proceeding, or other formal dispute resolution process, except as authorized under Rule 31D. So this one and the next sentence has actually been adjusted a little bit since the early days. This one says a legal document preparer shall not attend court with the consumer for the purpose of assisting the consumer in court proceeding unless otherwise ordered by the court. And that it used to just say that they couldn't assist a consumer, but as we all know, judges can oftentimes make their own rules. And so sometimes they will ask the legal document preparer to come in. I've not been asked to do that when I was in practice, but I was asked to come in as a witness and involving a dispute that came up about some documents that I prepared. So and then it says a legal document preparer shall not provide any kind of advice, opinion, or recommendation about possible legal rights, remedies, defenses, options, or strategies. This shall not, however, preclude a certified legal document preparer from providing the type of information permitted in subsection F1 of this section. And we have to tell them that we're not attorneys and so forth. Let's go back to that one issue, though, and that it says that we cannot make recommendations, advice or opinion or recommendation as to legal rights, remedies, defenses, options, or strategy. So that still has to do with giving advice. Earlier on in 7-208, it clearly states that document preparers can tell what the options are. They just can't tell the client what options to select. And so I think that that's one of the things that that we need to be aware of. We have a lot more abilities than we sometimes think we do. If somebody comes in and says, okay, what kind of deeds should I use on this? You know, in my case, I'd say I can't tell you that, but I can tell you what's available to you and what they do, and then they make the decision. So that's my view of this particular issue of performance in accordance to law. We want to stay within the law, but in the last part of this paragraph, it refers to not saying that you're a lawyer or whatever, and shall not use the designations of lawyer, attorney at law, counselor at law, law office, JD, Esquire, or other equivalent words. And the other equivalent words are kind of a problem, can be kind of a problem. I remember many years ago, the issue came up that in some Hispanic offices, they were because they were notaries, they were saying calling themselves notarios, and the court got kind of upset about that because in I guess in the Hispanic community, notarios means lawyer, and or at least in Mexico and other Spanish-speaking countries, and so they really kind of and they went after a few people for using that, and so I think it's something we need to kind of be careful of. I had a woman come in one time. This is back when we did do bankruptcies, and she'd gone to a bankruptcy document preparer, and she said he had a law degree on his up on his wall, and and he did some things that were very illegal and very inappropriate to her, and so anyway, she made some complaints, and they went after the document preparer, not only for that, but for the very fact that he had a law degree posted on his wall. And I thought about that a lot at the time, and I thought, well, if you have a law degree or any other kind of a degree, why should you be restricted from promoting it? And their argument was, this makes the customer think that you're a lawyer. And I'm not sure about that. I'm not sure that that's true, although in some cases it made a difference to this woman. She thought, if he has a law degree, he knows a lot more about what he's doing than if he was a document preparer. And so I think that it's important to know what the rules are about that, because the Board of Certified Document Preparers has gone after quite a number of people for those kinds of what they call violations of the code. So we just have a few more minutes left, and so I'm going to propose a few questions, and if you want to answer them, fine. If not, I'll tell you the answer to them. So the first one is, I do have a JD law degree. Not me, but let's say I have. Can I put it on my business card? Can I put Alan Merrill, JD? No? Okay, why not?
Appearance of
Most people-
impropriety.
Right, it's impropriety. It's giving an idea of something that's not true, right? Okay,
Yeah.
so
By the way, Alan, I think along the same line you do. While I understand it, and that is the policy, I don't necessarily agree with that. If you earned your law degree, I do have just a problem with that. But I understand the rationale, and I understand that's the policy. So it is what it is. But
yeah, that's right. I kind of dislike that approach, but I think that it's something we have to be very, very careful about. And so we did a divorce for a woman 10 years ago. Now her ex-husband wants us to help him with modifying the child support. Should we do it? Can we do it?
so 10 years ago, 10 years
Yeah.
ago did divorce, and who was the client 10 years ago?
The woman, the wife. Now
The
the
wife. And so-
ex-husband is in, and he wants us to help him with modifying the child support. So, okay, so far I got 2 no's, 3 no's, I guess. Yeah, and it is a conundrum, as one of my sons says sometimes. We have a conundrum here, perhaps. It's 10 years. We don't even know who this woman was. Yeah, Linda is saying we could do it, but probably shouldn't. And so one says the matter's been adjudicated, all this kind of thing. And what'd you say, Rob?
I said you can, as long as the original client agrees to it, the conflict is disclosed and agreed to, and the better option would be say, sure, I can do it, but your wife has to be the one that initiates it, or you guys agree to it together.
Yeah. Okay. All right. So there's a lot of iffies on these questions, aren't there? So that we have to be kind of careful about it, because they can come back to slap you in the face if you make the wrong choice about it.
So,
So,
Alan, what's the underlying issue? Why couldn't you? Why not? Why not yes?
Okay, well, the underlying issue is particularly if you remember the case, or you know the case, and you may know things that will be detrimental to your former client, to the woman. So you just have to be. I mean, the whole idea is that you need to be an impartial observer, in a sense, of what's going on, and do the documents, and without worrying about making comments or saying, "Oh yeah, I know, I remember her. She was really a handful." You know, you could do anything like that, and you have to be. That's what the courts and what the program wants to avoid.
And I appreciate you clarified that's the underlying issue, that you have information about the other client, and it would be improper for you to take that other job. But let's change the scenario a little bit. Let's say same scenario, except now the former husband is coming to you to do an LLC.
Okay. You mean the husband?
Yeah.
Yeah.
Yeah. Is that okay?
I I wouldn't have any problem with it. I don't know if other people would or not, but I would see no problem with it, since it's not dealing with any kind of familial relationships. Uh, and I just would not have a problem with doing it. But some people might, and may feel better about it, but I wouldn't. Yeah,
So
I've got one.
Diane says I would still say no because of the appearance of impropriety. Linda
Right, I
says
see
we
that.
know we'd be impartial, but it's the program board to worry about and not worth it.
Yeah. Okay. All right. So, and I think a lawyer wants to refer business to us. Can we split fees with him? Who wants to answer that one? No, no,
No,
no.
no, 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 no.
Okay. All right. No fee splitting. That's right. So, so what happens if the lawyer hires you to do the paperwork? No, but drinks are okay, Linda says. I've done work for lawyers. I've done document preparation for lawyers in the past. And he does pay fee. The lawyer pays you whatever your fees are. I don't really see a problem with that. Depends on the lawyer, I guess. But I think we were okay with that. Okay, now a client wants us to do a response to a divorce petition. He says, just review the petition and format a response for me. Can we do that? No, no, this is not a client it's not based on whether the client is represented by a lawyer or not. Okay, you cannot do that because why? If you're formatting a response just by looking at the petition, you, in essence, are giving legal advice. So that's why it's important to know exactly what your client wants to say and wants to do. And I have a client right now. I don't really do in the doc. I'm not in the document. Rob owns all the business now. He's just letting me use his office here. But I have a client who is in the process of objecting to a motion that was filed to do away with the guardianship. And these were the guardians, and they don't have any money and so forth. So, and they are long time tax clients of mine. So they asked me to file an objection to this and or draw up one. And so what do? Do I look over what the other attorney has done that's asking for the guardianship to be dissolved, or what? And so here's what I did do. I said, you write out what you want me to say. You write out the gist of what you want to say and why you're objecting to this. And then I will put it into the petition format. And that's what we're going to do. It has to be your idea and you sign it and you know exactly what you're going to do, which it turned out was fairly easy to do because they were pretty clear about what they felt. So now we come to the next issue, which Don knows a lot about and I've had some experience with. It says, I know quite a bit about the law, and I'm sure many of you do know a lot about the law. Can I refer to case law, precedents, or cite statutes in preparation of legal documents? Let's see some answers here.
Come on, it's just between us.
Yeah, we're not going to force, we're not going to turn this over to the board. Yeah. Under the direction of the client, Okay, well, the client, the client doesn't know anything about the precedents, about cites, about statutes, and so forth. Okay, well, the reason I asked this question is because it has come up over and over again over the years. And that's actually one of the issues that, okay, all right, so if it's factual information, tricky. If you get called to the stand, you better know all your citations, all those kinds of things. And it is tricky because this has been at the core of at least the former staff attorney for the board, because he didn't think we should be able to do that. And he said that we should not, that is the practice of law. Well, is it? It isn't really, I don't think. And the next question is, if you can't do that, how can you prepare a proper document in some instances? So it's another conundrum. But I think the rules are such that now and the effort on the part of the board and all that are kind of moving in the direction that if you have these set up as Don has on as a standard wording document, then those things can be used. But it's kind of a difficult situation to deal with because in the past there's been quite a number of document preparers that they attempted to discipline because of this, and they were successful in a couple of situations. So I think that it's something, if you do it, you need to be careful that it's something that your client has approved and has looked at and understands.
Alan, can I read some of the response in the chat?
Yeah, go ahead.
So, all right. So, Scott states that if you get called to the stand, you better know all of your citations, etc. It's a gray area, but best to say no. Barry says, I only refer to statutes, case law, etc. if it is factual information. Patricia says the client can get that information from an attorney and relay the information to us. Carol says it's tricky. Susie says statutes, rules of the court only. For general information, case law helps form your argument and opinions, which is UPL. And then Linda says you will have to prove to the program that it's written or verbal template. You tell everybody in the same situation. I found this out the hard way. I'd like to comment on what Linda just said, and Alan, you said this as well. I think this is what you were saying. I think it's still it's a gray area. It's definitely not, in my opinion, is not something that's been determined. And let me qualify that statement. I think it was absolutely determined for the first 6 years that the program existed, that we could cite case laws or at least cite statutes, rules, case law. I will tell you, and I think Alan and Linda would probably back me up. I don't want to speak for you two, but that these issues were specifically discussed in the ad hoc committee that put together the program, and there were to be no prohibitions on this. However, it is what it is, and that position has either been lost over time or changed, or however you want to look at it. And I think it's in a gray area right now. I agree with what Linda said, that I think if you're going to do these things, that at least for some of these types of pleadings, where you can have a standard template that already and I'll make it simple. Let's say you have clients that may periodically need to do motions to expand the time to serve someone, with a pleading, or continue a hearing date. There certainly is an easy way to put the typical rule that you're going to cite every time into a template, and that I think that is going to probably be okay in most cases. But again, there's some gray area, and I can't say that everybody in the program agrees with that. But I know I don't mind acknowledging or admitting that I in the past, and it's been a number of years, but I have had some issues, or one particular issue with the board on those issues, and that is the message that I got from it, that kind of saved me in certain respects, that I was using a template, and I was using a template that happened to cite the same rule with every client in the same situation. And so I was not representing that's the only way that you can do a motion to continue, or it wasn't just that, but that was an accurate way to do it. And I'm right about that. And so I think that saved me, but it may be playing with fire in some circumstances right until this gets resolved.
I will say, though, that in disciplinary proceedings, most of the disciplinary proceedings, the reason that most of them were unsuccessful in terms of the board coming after somebody is that in 7-208, there is no prohibition about these kinds of things. And so for those people who put up a fight, hired a lawyer or whatever it might be, they won usually. And that is the reason that the staff attorney tried to change 7-208 to specifically include some of those things. And there was such a response that it has kind of dribbled away. And our attorney, Brian Locker, met with them and filed basically a threat that we would be fighting this to the Supreme Court if necessary. And so all these things come into being. It's just, we're not telling you cannot do that. We're saying this is something you need to understand the risk. And if you can see that you are on the level and you do it maybe the way Don does it, I think is one way of lessening the risk. In my case, I almost never do that anyway. I just simply write in plain language what my client wants to say. But I can see where using statutes or precedents or other things, it would, in some cases, would be a stronger argument. So anyway, we're kind of at the end of the time. We are at the end of the time,
Yeah.
I guess. So the board, this somebody just said verification can't hurt, but oh, it was Linda. The board likely won't care. Well, the board can do a lot of things, but sometimes they can't overcome the fact that in the rule itself, so far, there is no real prohibition on it. So, and I think they've decided that this is not worth the trouble. So, anyway, that's my story, and I'm sticking with it. So,
Well,
you guys have a good. You guys have a good afternoon. Huh?
Thank you, Alan. Great job. I
You bet.
appreciate it. All right, everyone, that's
Thanks.
the only thing left to do is for me to hold up the last word, and I'll speak it as well and spell it out as well for verification. But I thank you all for attending. I thank you all for the participation as well. And I thank all the presenters. So the last verification word is INK, I-N-K. And hopefully you can all see this. But if you get the last word, you're free to go. We appreciate you participating, and we'll send you information on the next class, which is at the end of February. But we'll send that out in a week or so. Yes, so you just send me an email with the 3 words, and I probably will not respond with the certificate any sooner than this evening, but because I do them one at a time, but I'll get them back to you in the next 2 days. But you're welcome to follow up with me if you don't get it, but you'll all get it.
Thank you for the great program.
The same email that I sent you all the notices so far. So you can just reply to the last email I sent to you. Yes, AAIP continuing education at gmail.com. Thank you, Scott. So, and it's good to see so many of you. Okay, hopefully everybody got it.
We did. Thank you.
Okay. All right. Thank you, Kelly. I believe we can, Chris, do all 10 hours online. I was looking, a couple people have asked me about that as well, and I was reading that today, and I don't see anything that prohibits that. I think there used to be some language that did, but I don't see anything that prohibits that.